We'll be discussing majority powers and minority rights, an important topic among others in company law. Protection of minority shareholder is an important aspect and to be protected. Look, when you are having shareholders in the market, then there will be shareholders who are in majority, there will be shareholders who are in minority. So as the general thing is majority wins, and it happens all the time. So who will be protecting the minority right? How the rights will be protected in the company? For that purpose these provisions are there, but it does not mean that only minority rights are being hampered or harassed. No, majority, those who are in majority right, majority power, they may be a victim. That will be clear in further discussion among the topic. In Rajmundry Electric Supply Corporation Limited versus A. Nageshwara Rao, court said that court would not interfere at instance of shareholders until directors management are working as per article of association and memorandum of association. So unless directors and these management, they violate article and memorandum, court will not interfere. So it goes with the theme that state should interfere minimum, law should interfere minimum, law should facilitate. So that's why the court is reluctant to interfere unless there is some violation of article or memorandum or some other criminal activities like fraud and similar aspects are there. Till the time court will not entertain. Now many decisions are being taken by the management, so they are not open to challenge in court of law, because management directors by virtue of their experience, they take the decision keeping in mind the market. So few shareholders may not like it, they may think that this will not generate good profit, but other decision may generate good profit, and in fact it may also, and in fact what they are saying may be correct, but again that comes with objectivity. So nothing connected with the internal disputes between the shareholder is to be made the subject of an action by a shareholder. This statement was said in Force versus Horbutter 1843. Nothing connected with the internal dispute between the shareholders is to be made the subject of action by a shareholder. So what is your internal dispute? You should resolve it internally. If something allowed by majority shareholder by virtue of power given to them, that will not be put in question by any shareholder. However, company can put them in question, but not any person like shareholder. So if power is being used, then company can put that in question, but not any person like shareholder. For example, why you are taking decision, why you are acquiring X company, why you are not acquiring Y company, we should start our business in biotechnology, why you are focusing on these plant varieties business only. So a number of examples could be there. Now exception to Force and Orbital rule. First exception, act is ultra vires. Okay, so if act is ultra vires means beyond power, then court will come in between and court will take note of the matter. In Bharat Insurance Company Limited versus Kanhaiya Lal, object of company was to advance money at interest on security, but company advanced money without security. Shareholder challenged the act and act was found to be ultra vires. Fraud on minority. Example, taking away rights of minority shareholder by altering article of association. So this would be a fraud on minority. Acts requiring special majority. If no special resolution is taken and only ordinary resolution is required, meaning thereby act requiring special majority. If act requires special majority but that has not been taken off, if there is special resolution required but it has not been taken on, or ordinary resolution was not required but it has been taken, so in such case court will interfere, because now they are kind of breaching their power. Individual membership right. Individual membership rights. Companies Act, Article of Association, they provide rights to shareholder. In Carus versus Lloyd property, what happened? The director, instead of retiring as per Article of Association, as per the tenure, he was to retire, but he did not retire and kept on holding the office. Shareholder challenged this and they succeeded. In such things, court interfere, otherwise court do not interfere. Then oppression and mismanagement. Oppression and mismanagement will cover with this chapter 16, prevention of oppression and management, also section 241 to 246. Basically, if minority or even majority, they are oppressed, and because of that mismanagement things are not happening as they should be, means violation of article or violation of companies law is happening, then court will interfere. So apart from topic minority right and majority right, the current topic confers rights also known as qualified minority right, providing both judicial as well administrative remedies. Now these rights remedies can be used by majority also, as stated earlier. So chapter 16 section 241 talks about application to tribunal for relief in case of oppression. Section 242 talks about power of tribunal. Section 243 talks about consequences of termination or modification of certain agreements. Section 244 talks about rights to apply under Section 241, who can apply. Section 245 talks about class action, when a particular class takes the action. Section 246 talks about application of certain provision to proceeding under Section 241 or Section 245. Word oppression and mismanagement have not been defined under the Act, but these terms have been given broad generic sense instead of giving strict literal sense. So the meaning is considered in broad generic sense. In Shanti Prasad versus Kalinga Tube, oppression, visible departure from fair dealing on which shareholder rely. So this is the meaning given to the term. Now there are these cases and the interpretation of the terms, but you need to understand what exactly oppression is. In very layman language, when violation of Companies Act, violation of Article Association, or violation of any other law time being in force related to this company's activities is happening, and one or more of the members, their rights are being taken away, or one or the another way they are being harassed by those decisions or by those activities, amounts to oppression. And obviously it happens because of mismanagement. Now, Hindustan Cooperative Insurance Society, life insurance business was acquired by LIC on payment of compensation. Director with majority voting power refused to share the amount with shareholder. Now this compensation, which was taken by the director by the notion of acquisition, they refused to share it with shareholder, and they passed a special resolution and changed the object of the company. Now you have studied memorandum of association, you know that company has an object for which it works. Now they changed the object of the company. So this was challenged, and it was held that oppression is in this case is established because authority was exercised in harsh, wrongful manner. Minority right holder forced to invest money in different kind of business. When object change, your business portfolio also changes. Today you are working in X industry, you will change your object, you will be working in Y industry. Today you are working in manufacture textile industry, tomorrow you will be going for infrastructure industry. So these shareholders, they have invested money for the earlier object, not the later on. Now it is again a matter of kind of subjectivity. Company can change, memorandum, alteration to memorandum can happen, but it depends upon the fact and cases of each case, fact and circumstances of each case. Lalita Rajya Lakshmi versus India Motor. Now act of mismanagement may not be oppression all the time. Obviously, allegations were that income of company was shown less, fuel consumption was not properly checked, Dividends declared were less. Court said that these are not instances of oppression, even if proved and satisfy the court that these things exist. Look, mismanagement is something different. Mismanagement means you are not doing the things properly. Maybe you are not keeping the records properly. Maybe you are not serious. Section 241 talks, any person may apply to tribunal who complains that, 241 clause says, any person may apply to tribunal who complains that affairs of company have been are being conducted prejudicial to public interest or to the specific person, to him, the complainant, any member or company's interest. So if affair of company have been or are being conducted and it falls in any of these criteria, and then material change against debenture holder, creditor and shareholder has taken place. How? Taken place in management of the company. So how this change has taken place, whether by alteration in board of directors, manager, ownership in company, whatever the way is, or if company is not having share capital, then by alteration in membership or otherwise, affairs of company would be prejudicial for its member. So what comes out is that something is happening at prejudice of the member of the company. Affairs of the company have not been taken care of. 241 clause 2 says, central government, if in its opinion finds affairs of the company prejudicial in public interest, may itself apply to tribunal that affairs of the company should be checked and oppression is happening. 241 clause 3, if in opinion of central government there are circumstances that, how many circumstances? A, B, C, D. There are circumstances that person concerned in affair of company is or has been acting contrary to law or under breach of trust. Look, is or has been, is not, has not been, meaning thereby this is kind of a continuing thing. Okay, it does not mean that a thing one happened does not result in oppression. It may be, but usually it's a continued thing. So person concerned in affair of company is or has been acting contrary to law or under breach of trust. B, business of company is not, has not been happening as per sound business principles or prudent commercial practices. Sound business principles, prudent commercial practices. Suppose there is demand of the product in the market and then you can increase the price, but you are reducing the price. You are putting the price at minimum, or you are taking loan at higher rate of interest, or for example you are a lending company, you deal in investment, so you are lending money at very less rate of interest. So these are not sound business principles and these are not prudent commercial practices. N number of examples are there. Then company is being managed as resulting in injury or causing damage to trade, industry or business to which such company pertains. So they are again kind of not going through the sound business principles. It can be understood in that way. These points may overlap, but they have their by virtue of technicality of the business portfolio, they have their independent stand as well. So they are hampering the particular industry, and then business is or has been happening with intent to defraud its creditors, or for unlawful purpose, fraudulent ways it is happening. So if in opinion of central government there are circumstances that one or more than one of these things are happening, central government may initiate case in tribunal to have fitness of such person to act inquired into. The directors, board of directors, CEO, whoever the concerned person is, whoever this concerned person are, central government may initiate case that please check their fitness, whether they are capable to act or not. Now section 241 clause 5 talks about the application under 241 clause 3. The central government, when applying to tribunal, this application shall contain concise statement of circumstances. What leading central government to the opinion, concise statement of circumstances, and shall be signed and verified as per code of civil procedure, like you verify and sign a plaint, when you verify and sign a plaint. Now 242 talks about powers of tribunal. 242 clause 1 says, if as application under 241, tribunal is of view that affairs of company are happening in some prejudicial manner, or winding up should be done, but it will unfairly prejudice to members. Look, this is the situation which allows winding up, but when you wind up, then it will affect the other members. So there are circumstances, but that does not mean winding up is the only option left. So if based on the application under 241, tribunal is of view that yes, affairs of company are happening in prejudicial manner and winding up should be done, but it will unfairly prejudice the members, may make any order to bring an end to the matter. What kind of order? So clause 2 says, an order under that subsection may provide for regulation of conduct of affairs of the company in future, how affairs of the company will be regulated, the purchase of share or interest of any member of the company by other member, how this will happen, purchase of its share by the company as aforesaid, buyback, which we have studied earlier also, restrictions on transfer or allotment of shares of the company, how transfer and allotment will happen, and then the termination, setting aside or modification of any agreement between the company and the managing directors, termination, setting aside or modification of any agreement between company and any person other than referred to in clause E, managing director, any other director, manager. So except these person, other will fall in F. The setting aside of any transfer, delivery of good, payment, execution or other act relating to property made or done by or against the company within 3 months before the date of application. So court may set aside any transfer, any delivery of goods. For example, company has transferred its property, or company has delivered goods to another person at very low price, or they have made certain wrong payments which are not required to be made, or execution or other act relating to property. So these acts and acts related similar acts, so court may set aside if they have been done within 3 months before the date of application. So you need to learn these, and these are very much explanatory in themselves. Removal of managing director, manager or any of the directors of the company. So tribunal may remove director or manager, then that seat will become vacant and the director will be disqualified. Recovery of undue gains made. If it is possible, then court will order for recovery. For example, payment has been made, but you can identify the payment. Goods have been delivered, but you can identify the goods. The manner in which the managing director or manager of the company may be appointed. The manner of appointment of managing director or manager, that may be, court may provide how to do that. Appointment of such number of persons as director who may be required by the tribunal to report to the tribunal such matter as tribunal may direct. Now tribunal can appoint directors, and these directors will be reporting to tribunal. Imposition of cost as may be deemed fit by the tribunal. Tribunal may impose cost on the company and any other matter for which in the opinion of tribunal is just and equitable. Whatever tribunal thinks is just and equitable, tribunal can take that order. Now these are judicially determined discretion. These are not subjective discretions. These are objectively played one. So this is 242 clause 2 A2M we just covered. Now 242 clause 5, what it talks about, it says if tribunal made alteration to article or memorandum of the company, then company without permission of tribunal cannot alter memorandum or article. If tribunal made alteration to memorandum or article is done by tribunal. In that case, company cannot alter memorandum or article without permission of tribunal, which goes against alteration made by the tribunal. So they cannot supersede or cannot bypass the alteration made by the tribunal without its permission. 242 clause 8 talks about if company contravenes. 242 clause 5, company contravenes, then what is the liability? Company's liability, company may be punishable with fine not less than 1 lakh, which may extend to 25 lakhs. And every officer in default, he will be punished with fine not less than 25,000 but extend to 1 lakh. Then consequences of termination or modification of certain agreements, 243. So in 242 also we studied that court may set aside or terminate the agreement. So what are the consequences? So it says that if under section 242 tribunal terminate, alter an agreement, then such order shall not give rise to any claim against the company. So company has entered into agreement with Mr. A, and then this agreement has been terminated, altered by the tribunal, then Mr. A will not be having any claim against the company, and no managing director or other director or manager whose agreement is set aside. Okay, managing director, other director or manager we have studied in 242 clause 2 A2M. These were mentioned there. Whose agreement is set aside, he will not be appointed as director or manager for 5 years from such order of termination without the leave of court. You need to take permission of the court, and you cannot appoint him as director from 5 years of such order of termination. Now right to apply under 241. Who can apply under 241? Section 244 talks about, and it says following person can apply. First, company having share capital, and then company not having share capital. So if company having share capital, then not less than 100 members or not less than 1/10 of the total member, whichever is less. This is the one condition, not less than 100 members or not less than 1/10 of the total member, whichever is less, or any members holding not less than 1/10 of issued capital, issued share capital, meaning thereby they are holding not less than 1/10 of the share capital, provided that all calls and other sums have been paid. There is nothing due on their share. So these two, if company having share capital, then these two requirements. First is not less than 100 member or not less than 1/10 of the total member, whichever is less, or any member or members holding not less than 1/10 of the share capital. Then company not having share capital, not less than 1/5 of the total number of its member. Now tribunal on application made to it may waive all or any requirement as above mentioned. It depends. In public interest, tribunal can do so. Then 245 talks about class action. It says all or any action, A to Z. Let's see what it talks about. So this section basically talks about members or depositors. So clause 1 says, so if member or members or depositor or depositors or any class of them, okay, members or depositors, they think that management or conduct of affairs of company are not happening in a proper manner, they are happening manner prejudicial to interest of the company or member or depositor, so they can file before tribunal and seek all or any of the following orders. First, to restrain the company from committing an act which is ultra vires, to injunct the company, restrain the company, to restrain the company from committing breach of any provision of company's memorandum or article, to declare a resolution altering the memorandum or article of the company as void if resolution was passed by suppression of material fact or obtained by misstatement. So you can alter the memorandum, but this is not the right way, where you suppress the material facts and obtain the consent by misstatement. To restrain the company and its directors from acting on such resolution, if resolution has been taken wrongly, then they should not act on that. To restrain the company from doing an act which is contrary to the provision of this act or any other law for timing force. Again, these are self-explanatory and you need to learn them. To restrain the company from taking action contrary to the resolution passed by the members. To claim damages or compensation or demand any other suitable action from or against the company or its director for any fraudulent, unlawful or wrongful act. To claim damage or compensation or demand any suitable action. So they can claim damages or compensation or suitable action if company or its directors are acting fraudulent, unlawful, wrongful act, or if the auditor, including audit firm of the company, for any improper or misleading statement of particulars made in audit report. Audit and account is also an important topic, and accounts and audit report have to be very intact and very much clear and transparent. Any expert or advisor or consultant or any other person for any incorrect or misleading statement. So if company or directors are playing fraud, unlawful activities they are doing, wrongful act they are doing, the auditor have not mentioned proper statement and is mentioned improper and misleading statement in audit report, or any expert or advisor who is giving incorrect or misleading statement made to the company, or any fraudulent or unlawful or wrongful act. So they can claim damages and compensation. To seek any other remedy as the tribunal may deem fit. They may ask that in the interest of justice any order may also be passed. Section 242 clause 2, requisite number of members and depositors. How many members and depositors you need to invoke this section? Invoke this section. Members, company having share capital, and then company not having share capital. So company having share capital, not less than 100 members of the company, or not less than such percentage of total member as prescribed, whichever is less, or member having not less than such percentage of share capital as prescribed. So A or B, any of this condition, and company not having share capital not less than 1/5 of the total members. Now in case of depositors, not less than 100 depositors, or not less than such percentage of total number as prescribed, whichever is less among these two, or any depositor to whom company owes such percentage of total deposit of the company as prescribed. So condition A and then condition B. Clause 4 says that while considering the application under subsection 1, tribunal shall take into account in particular. So these are the instances which tribunal shall take into account while dealing with the application made under subsection 1. Whether the member or depositors are acting in good faith while making the application. If you want to do equity, if you want to have equity, do equity. If you want to have remedy, go with clean hands. So whether the member are playing in good faith or not. any evidence before tribunal as to involvement of any person other than director or officer of the company. Okay, so if any evidence is there that other than director and officers of the company, outsiders are also involved or not, whether the cause of action is one which the member or depositor could pursue in his own right rather than through an order under this section. For example, if because of internal remedies provided by the company, these member and depositor can seek remedy there, so first they are required to exhaust the remedy at company level, then only they will come at tribunal level. Any evidence before it as to views of member or depositor of the company who have no personal interest, direct or indirect, in the matter being proceeded under this section. So if they are not personally interested, it means they are publicly moved or they want the company to have in a good position. So all these factors will be taken into account by the tribunal while dealing with the application. These factors kind of, they filter the application, whether it's appropriate to entertain it or not, whether there are glaring circumstances. So these factors helps the court in considering those things. Where the cause of action is an act or omission that is yet to occur, means cause of action is yet to occur, it has not occurred, then whether the act or omission could be or in the circumstance would likely to be authorized by the company before it occurs or ratified by the company after it occurs. So if cause of action is yet to occur, then can company authorize it before it occurs, or can it company ratify it after it occurs? Because if company can ratify, then they may become sound now, they become silent now, and later on they will ratify it, or they may authorize it before it's happening. Where cause of action and omission has already occurred, so here it is talking about yet to occur, here it is talking about already occurred, then it has to be seen that whether that act can be ratified by company or not. If yes, and there are circumstances that yes, they are playing foul, then tribunal may take relevant decision. Clause 4 talks about considering an application, and then you have clause 5 which talks about if an application is admitted. Okay, so if application is admitted, then tribunal will have regard to following circumstances. If tribunal is considering the application, then tribunal shall take into account following particulars. So it takes about tribunal shall have regard to the following: public notice shall be served on admission of the application to all members or depositors. Suppose a depositor or a members, they have filed the application and it is admitted, then public notice will be sent to all other members or depositors so that they get to know what is happening and they can also put their presentation. All similar application, for example, more than the similar application has been filed in more than one jurisdiction, then court will consolidate it. Two class action applications for the same cause of action shall not be allowed. Two class action, different classes are there, that's why they are not being allowed, because different class may have different notions and different requirements. The cost or expenses connected with the application for class action shall be defrayed by the company or any other person responsible for oppressive act. So this cost and expense which is connected, it will be taken out of the company or the person who is responsible. Then 7 talks about the punishment. So any company fails to comply with the order passed by the tribunal under this section, any of the order which has been passed by the tribunal under this section and company fails to comply, then company will be punishable with fine not less than 5 lakh rupees but may extend to 25 lakh rupees. And then every officer of the company shall be punishable with a term which may extend to 3 years or with fine. Now fine shall not be less than 25,000 rupees but which may extend to 1 lakh rupees. So punishment is there for company and for defaulting officer. Then clause 8 talks about where any application filed before tribunal is found to be frivolous, means wrong and bogus applications are there. So tribunal will reject and may ask the applicant to pay cost to the opposite party not exceeding 1 lakh. So again, it's a good move. You need to maintain the balance. So we are done with the topic.